The following is a message from Greg Brown as read by AI.
Hello, America. This is Greg Brown reporting to you from my prison cell here at the Washington State Penitentiary. I'm eating sausage I bought off the prison commissary. I cooked it in hot water for 6 hours because our hot pots don't get hot enough to boil. With some mustard, barbecue sauce, and relish, I wrapped it in a slice of bread. On the side, I'm eating an orange and a tomato. It's okay for a snack. So today I am telling you and all the world about the state of Washington stealing millions and millions of dollars each year from Washington state prisoners and families. They have got a real scam going on here in Washington state, and these attorneys are in on it. You see, they made a law saying they can take money from prisoners and from anyone who sends money to prisoners. But all of them know this law is illegal and unconstitutional. How do I know it's illegal and unconstitutional? Well, because other law says it is, and because prison systems all across the country tried the same stuff and the courts there shut them down. There was even one federal judge in Washington state who said it was unconstitutional and wanted to order the state to stop taking our money. But that prisoner, named Hoskin, who filed that lawsuit was in psychiatric treatment, and he said he didn't want it. It is really bizarre. The prisoner actually told the judge, "No, don't stop them." Crazy. Or maybe he was threatened and pressured. Who knows? This is such a huge deal, some people are going to want to act like I don't know what I'm talking about. So, I'm going to explain it to you in detail so you all can agree Washington state is out of pocket. I will be talking technical law, but we'll try to keep it as plain and simple as I can. On June 15, 1995, Washington State made a law. It's called Revised Code of Washington, RCW 72.09.480, that requires all prisons to deduct money from all prisoners' trust accounts. Under this law, the state takes at least 35% of the money that people send to prisoners. Or if the prisoner is serving life without parole, then it's 25%. Section 2 of this RCW says they're taking 5% of prisoners' money to pay crime victims compensation, 10% to be deposited into the prisoner savings account, and 20% to contribute to the cost of incarceration. In the year 1998, Division 9 of the Washington State Court of Appeals, in a case called In Re Personal Restraint of Metcalf, book number 92 of the Washington Appellate Reports, pages 165 and 180, this case upheld these deductions and also said the deductions are automatic from every prisoner who receive funds. Now, before I go any further, I want everybody to know I'm not talking about court fines or other penalties ordered by a court judge. Those deductions fall under different laws, and I'm not talking about any of those. I am only talking about the money that prison and DOC officials are taking under this RCW 72.09. On page 176, this crazy Metcalf case said the DOC is not denying us due process by taking our money. When it said this, the court relied on a 1989 10th Circuit Court of Appeals case called Oklahoma Education Association v. Alcoholic Beverages Laws Enforcement Commission, volume 889 of the Federal Reporter 2D series, pages 929 and 936. The first thing I thought when I saw this was, what does an alcoholic beverage case have to do with my money? Now, I don't want to get too far ahead, but 24 years later on February 7, 2013, in the U.S. District Court for the Western District of Washington, Lexus at 72787, the Hoskin v. Lewis case, pages 3 and 4, has ruled this Oklahoma Education Association v. Alcoholic Beverage Law Enforcement Commission case is not applicable to cases about money being deducted from a prisoner's trust account. So you see I was on point wondering, what does an alcoholic beverage case have to do with my money? Hold that thought. I'm going to get back to it in a minute. Under the cases that I'm going to tell you about, the prison system in Washington state is violating the constitutional rights of prisoners and prisoners' families. One of these cases is a 1966 United States Supreme Court case named Rinaldi v. Yeager, published in volume 384 of the U.S. Report series, page 305. Another case is 1,988 decisions by the Ninth Circuit Court of Appeals, called Schneider v. California Department of Corrections, published in volume 151 of the Federal Reporter 3D series, page F3D 1194. Another is a 2015 case by the Ninth Circuit Court of Appeals called Chenault v. Hawks, published in volume 782 of the Federal Reporter 3D series, page 1053. There is a 1991 Washington State Court of Appeals case named State v. Eisman, volume 62 of the Washington Appellate Report series, page 640, and footnote number 10 on page 644. And there are two Washington State Supreme Court cases. One in 1976 called State v. Barkland, volume 87 of the Washington Reporter 2D series, pages 814 and 817. And the last one is a 1992 case called State v. Curry, volume 118 of the Washington Reporter 2D series, pages 911, 915, and 916. I'll start with the Chenault v. Hawks case, where the state of California tried to take a prisoner's money to pay the costs of incarceration. On page 1059, the court stopped it by saying the prison must provide a hearing before they can take the prisoner's money. Next is the Schneider v. California Department of Corrections case, you see, because whenever anybody claims the state of Washington violated their rights involving property, the state always argues that we don't really have any rights that protect our property because property interests are not created by the Constitution. Rather, they are created, and their dimensions are defined by existing rules or understandings that stem from an independent source such as state law. They argue this because in 1972 that's what the United States Supreme Court said in a case called Board of Regents v. Roth, volume 408 of the U.S. Report series, pages 564 and 577. So then, in response to that, this 1998 Schneider v. California Department of Corrections case explained that this Board of Regents v. Roth case does not apply to situations where a prison takes money from prisoners. Just like the Hoskin case I mentioned earlier when I said hold that thought. So, here's the thing. Today I'm talking about old property rights, like Hoskin and Schneider are talking about. The Board of Regents v. Roth case is talking about new property rights that ain't got nothing to do with what we are talking about today. This Schneider case explained the difference between new property rights and old property rights. New property rights are created by the state, whereas old property rights arose out of common law. In order to fully understand this, just take a moment and think. In this country, Americans had a right to own property and money way back during the Wild West days, way before there was even a United States Constitution. We all had rights way before there was a Constitution. These rights were called natural rights, human rights, and are now more commonly called common law rights. Way back then, when government was developing and growing in power, the U.S. Constitution was created for the purpose of keeping this growing government from trampling on our rights. When you understand this, then you can understand how the Board of Regents case wasn't talking about our natural, human, common law rights when it said property rights are created and their dimensions are defined by existing rules or understandings that stem from an independent source such as state law. Didn't no state law make your human rights? God gave you these rights, not the state. So, you see, the Board of Regents case is not talking about your God-given natural rights, human rights, or common law rights. So, this Schneider case says the Board of Regents case did not give states power to roll back old property rights. In other words, power to roll back your God-given rights. Here are the words used by the judges in this Schneider case. They said, the state's reliance upon Roth, however, would be misplaced. The Ninth Circuit Court of Appeals has ruled that, understood in proper context, it is clear that Roth stands not for a theory of plenary state control over the definition and recognition of compensable property interests, as the state assumes, but for a much more modest proposition. Roth was a so-called new property case. In it, the court considered the circumstances under which state law might serve to elevate certain non-traditional forms of property, such as public employment, public assistance, state contracts and licenses, and other government largesse, to constitutional status. The Roth Court's recognition of the unremarkable proposition that state law may affirmatively create constitutionally protected new property interests in no way implies that a state may by statute or regulation roll back or eliminate old property rights. At pages 1200 to 1201, the Schneider case goes on to say, rather, there is, we think, a core notion of constitutionally protected property into which state regulation simply may not intrude without prompting takings clause scrutiny. The state's power vis-a-vis property thus acts as a one-way ratchet of sorts. States may, under certain circumstances, confer new property status on interests located outside the core of constitutionally protected property, but they may not encroach upon traditional old property interests found within the core. Now, I know that sounds complicated to most people out there. That's just the way the courts be talking most of the time. What it means is that the state can create new rights for you and for me, rights that did not exist before. Then the state can play with those rights that the state created. The state can twist them around, modify them, or even take them away like it never existed. The hand that giveth may taketh away. But the state cannot go messing with the rights you already had before there was even a state to begin with. Talking about your God-given, natural-born, human, common law rights. God gave you those rights and the state cannot take those away. In footnote number 5 of page 1201, the Schneider case clarified the point by saying, for instance, could a state, consistently with the Takings Clause, statutorily craft its property law in such a manner that deprived car owners of their rights in their automobiles? Homeowners of the rights in their houses? The questions are so absurd as to answer themselves. In other words, hell nah. Schneider says it's absurd to think a state can make a law saying your automobile is no longer yours, or your home is no longer yours. Your money. Now let me make it clear to everybody out there what the state of Washington is doing and how they are trying to spin it. The Oklahoma liquor licensing case is about someone being denied a liquor license. The state is the one that provides liquor licenses. You see the connection? A person has to ask the state for a liquor license, and the state can say yes or no. The same is true about government jobs, Social Security benefits, food stamps, and stuff like that. These are all new property rights that the Board of Regents versus Roth is talking about because they are all created by the state. But the money you work for and send to prisoners, that is your money. That is an old property right. Don't let the state of Washington steal your money by bamboozling you into thinking your money belongs to the state. It doesn't. What they're doing is crazy. Absurd. If somebody sends me money, anybody, whoever it is, Washington state steals 25% of it by pretending it's like Social Security or food stamps or public assistance or a liquor license. And they're stealing everybody's money. Unlike food stamps or public assistance or Social Security or alcoholic licensing, the government ain't got nothing to do with family, friends, and loved ones out there sending us money. Don't let these crooks bamboozle you by saying Hoskin lost his case. They certainly will try that. Page 16 of Hoskin's 2013 court decision shows the judge was trying to rule in Hoskin's favor and order the DOC to stop violating our right to due process. On page 18, the judge says, plaintiff has stated a viable claim for injunctive relief. At pages 17 to 19 of Hoskin's September 12, 2013 case at LexisNexis 130816, the judge noted that Hoskin disavows any due process violation, even though Judge Creature found that Hoskin's complaint sufficiently alleged a due process violation. Even the Washington state cases show that using this RCW 72.09.480 to take money from my prison account is unconstitutional, because RCW 72.09.480 does not contain the several safeguards against oppressive application that are mandated at page 814 and 817 of the 1976 State Supreme Court decision, State v. Barkland, Volume 87 of the Washington Reports 2D Series and page 644, footnote 10 of the State Court of Appeals decision, State v. Eisman, that I cited earlier shows that the courts of Washington have consistently said their statutes for taking money from people must have the following requirements. 1. Repayment must not be mandatory. 2. Repayment may be only on convicted defendants. 3. Repayment may only be ordered if the defendant is or will be able to pay. 4. The financial resources of the defendant must be taken into account. 5. A repayment obligation may not be imposed if it appears there is no likelihood the defendant's indigency will end. 6. The convicted defendant must be permitted to petition the court for remission of the payment of costs or any unpaid portion. 7. The convicted person cannot be held in contempt for failure to repay if the default was not attributable to an intentional refusal to obey the court's order or a failure to make a good faith effort to make repayment. Generally speaking, in Washington state, under RCW 10.01.160, a defendant who has been ordered to pay costs and who has not willfully failed to pay the obligation, as described in RCW 9.94A.6333, 9.94B.040, and 10.01.180, may at any time petition the sentencing court for remission of the payment of costs or of any unpaid portion thereof. If it appears to the satisfaction of the court that payment of the amount due will impose manifest hardship on the defendant or the defendant's immediate family, the court may remit all or part of the amount due in costs. Manifest hardship exists where the defendant is indigent as defined in subsection 3 of this section. RCW 10.01.160, a defendant is indigent under RCW 10.01.163d if he has compelling circumstances that exist that demonstrate an inability to pay. The first problem is that we are not permitted to petition the court for remission of the payment of costs or any unpaid portion as provided for in prong 6 of the State v. Eisman case that I mentioned a minute ago. The second problem with the application of RCW 72.09.480 and stealing our money is that repayment is mandatory. As I said a moment ago, the first prong in Eisman is that repayment must not be mandatory. Remember, the Metcalf case says these deductions are automatic from every prisoner who receives funds, regardless of whether the prisoner's crime of conviction involved restitution. So this RCW 72.08.240 is in clear violation of the Eisman case. Because of these two problems, the application of RCW 72.09.480 violates State v. Curry and State v. Barkland and is unconstitutional. Last but not least, taking money from my prison account violates equal protection of the law, as explained by the 1966 United States Supreme Court case, Rinaldi v. Yeager, Volume 384 of the U.S. Report Series, at page 305. The Supreme Court ruled a statute requiring reimbursement from a convict's institutional earnings unconstitutional because that law required no such repayment from one fined, given a suspended sentence, or placed on probation. This court found this New Jersey law unconstitutional because it fastens the duty of repayment only upon a single class of unsuccessful appellants, those who are confined in institutions. We find that the discriminatory classification imposed by this law violates the requirements of the Equal Protection Clause. Rinaldi, 384 U.S. at 308. Even though Rinaldi was decided 58 years ago, the same discriminatory treatment is still happening now in Washington state. Instead of applying this RCW 72.09.480 equally to everyone convicted of a crime, Washington state is singling out those who are given prison sentences. RCW 72.09.480 is not applied to those who were only given fines, suspended sentences, or probation. The use of RCW 72.09.482 therefore denies equal protection under the 14th Amendment. This Rinaldi case put to rest the notion that a state can say it was necessary to discriminate. The Supreme Court said, to fasten a financial burden only upon those unsuccessful appellants who are confined in state institutions, however, is to make an invidious discrimination. An appellant subject only to a suspended sentence or to probation is likely to differ from an inmate only in the extent of his criminal record. That, too, is a trait unrelated to the fiscal objective of the statute. Finally, the classification established by the statute cannot be justified on the grounds of administrative convenience. Any supposed administrative inconvenience would be minimal, since repayment could easily be made a condition of probation or parole, and those punished only by fines could be reached through the ordinary process of garnishment in the event of default. Rinaldi, 384 U.S., at 309 to 310. In violation of the legal principles announced in Rinaldi, Washington state singles out prisoners to use their RCW 72.09.480 just because it's convenient to do so. Rinaldi clearly requires that, in order for Washington state's RCW 72.09.480 to satisfy equal protection, it must be applied equally to people who are given fines, suspended sentences, and probation. It is not. Therefore, it violates the Equal Protection Clause of the United States Constitution. This Schneider case, this Hoskin case, State versus Barkland, State versus Eisman, State versus Curry, and Rinaldi versus Yeager, they expose how these attorneys in the Metcalf case sold us out. The attorneys in the Metcalf case should have argued that the alcohol license case does not apply to our situation and does not allow the state of Washington to take money from prisoners' trust account, because our right to our money is an old property right that originated in common law. The attorneys in the Metcalf case, their names being James R. Dixon and Catherine A. Russell, for Nielsen, Bromham and Associates, PLLC. They didn't even mention Rinaldi or Schneider or Barkland or Eisman or Curry, even though each of these cases were already out and available to them when they made their arguments in Metcalf. If they had mentioned any of these cases, then prisoners in Washington state would not be paying millions upon millions of dollars contributing to this scam today. So now that the entire world knows all about how the state of Washington is stealing millions upon millions of dollars from its prisoners and their families, I hope that someone will step up and do something about it. If anyone wants to join me in stopping this madness, then please let me know. Greg Brown, number 281829. Washington State Penitentiary. 1313 North 13th Avenue. Walla Walla, Washington, 99362.